Hello everyone, this is your host Sayyid Amir Hussain. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Starting with a big update in the NEET matter, the Supreme Court on Tuesday, July 23rd refused to cancel the NEET UG 2024 exam on the ground of paper leak and malpractices. The court stated that there was no material to indicate that the leak was systemic, affecting the sanctity of the entire exam. The court also stated that ordering a re-examination will lead to serious consequences affecting over 23 lakh students and will lead to disruption of the academic schedule, causing a cascading effect in the coming years. While acknowledging that there was a paper leak in the centers in Hazaribagh and Patna, the court said that there is absence of material on record sufficient to lead to the conclusion that there is a systemic breach in the sanctity of the exam. A bench comprising Chief Justice of India D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Misra passed the order in a batch of petitions seeking to cancel the National Eligibility Cum Entrance Test held for undergraduate medical admissions on May 5, 2024 for paper leak and malpractices. The result of this exam were declared on June 4th. In an important judgment, the Supreme Court on Tuesday, July 23rd held that bail orders should not be normally stayed. Setting aside an order of the Delhi High Court which stayed the bail granted in a money laundering case, the court stated that bail orders can be stayed only in exceptional circumstances. The bench, comprising Justice Abhay S. Oak and Justice Augustine George Massey, pronounced the verdict in a petition filed by Parvinder Singh Khurana, an accused in a money laundering case. In a previous hearing on July 11th, the court expressed shock at the Delhi High Court's decision to stay a regular bail order without providing any reasons. During the hearing on July 11th, Justice Abhay S. Oak questioned the Directorate of Enforcement or the ED for defending the prolonged interim stay on the bail order granted by the trial court in June 2023. In other important news, the Delhi High Court on Tuesday transferred to the Central Bureau of Investigation or CBI the investigation into the death of 23-year-old Faizan, who was allegedly forced to sing the national anthem during the 2020 Northeast Delhi riots. Justice Anup Jairam Bambani allowed the plea moved by Kismatun, Faizan's mother, seeking SIT investigation into her son's death. The plea was filed in 2020. I am allowing the petition. I have transferred the investigation to the CBI, the court said. The incident relates to a video that had gone viral on social media wherein Faizan was seen allegedly being beaten by the police along with 4 other men while being forced to sing Vande Mataram. The mother alleged that the Delhi police had illegally detained the man and denied him critical health care, as a result of which he succumbed to his injuries on February 26, 2020. In a crucial development, the Supreme Court today on July 23rd delivered a split verdict on petitions challenging the approval given by the Union government to release genetically modified mustard. While Justice B.V. Nagaratna quashed the approval given by the Genetic Engineering Appraisal Committee and the Ministry of Environment and Forests, Justice Sanjay Karol upheld the same. In view of the difference of opinion, the bench directed the registry to place the matter before the Chief Justice of India to constitute a larger bench to hear the matter afresh. It may be recalled that during the hearing of the petition, the Union government had agreed not to implement the decision. The division bench pronounced its verdict in a batch of PILs challenging the Union government's decision to commercially cultivate, release genetically modified mustard Christian HT mustard DMH 11 into the environment. This is the first time a transgenic food crop is planned to be cultivated in India. Next, we have a news relating to Section 307 IPC, which deals with attempt to murder. The Supreme Court held that when the sentencing court doesn't deem fit to impose a life sentence for committing an offense of attempt to murder, then the maximum sentence that can be imposed on the convict for committing an offense of attempt to murder could not extend beyond the period of 10 years. In a sense, the court said that the trial court could not impose a sentence beyond 10 years if the convict were not awarded life imprisonment for committing an offense of attempt to murder under Section 307 IPC. Section 307 describes the punishment for committing an offence of attempt to murder, where the first part provides a maximum sentence of imprisonment of up to 10 years and a fine, and the second part provides imprisonment for life in case hurt is caused during an attempt to murder. In the present case, the accused challenged the imposition of 14 years of imprisonment under the second part of the Section 307 IPC. In a matter of Senthil Balaji, it was argued on behalf of former Tamil Nadu minister before the Supreme Court on Monday, July 22nd, that the deposit of Rs 1.34 crores in his bank account from 2013 to 2021 is not for the alleged cash for job scam, but from his agricultural income as well as his salary as an MLA. The MLA and former minister was arrested by the Enforcement Directorate in June last year in a cash for jobs money laundering case. He has challenged a Madras High Court order denying him bail in a money laundering case over the cash for jobs allegations. A bench of Justice Abhay S. Oak and Justice Augustine George Massey yesterday heard the arguments of senior advocate Mukul Rohtgi, who appeared for Balaji. During the proceedings, Rohtgi contended that the search and seizure effected by the investigation agency, which forms the basis of allegations against him, is tainted and no reliance can be placed on it. The Supreme Court of India clarified that the Motor Accidents Claim Tribunal, or the MACT, has the discretion to release the compensation all at once or in parts. A bench of Justice M.M. Sundaresh and Justice Arvind Kumar was dealing with a petition contending the Rule 150A of the Central Motor Vehicles Amendment Rules 2022, read with Annexure 13, interferes with the MACT's power under Sections 168, 169 and 176 of the Motor Vehicles Act 1988 to award compensation. Rule 36 of the Annexure 13 provides that the MACT shall release a portion of the awarded amount as necessary based on the claimant's financial condition and direct the rest to be placed in fixed deposits, to be released in phases as per the MACT annuity deposit scheme. The court dismissed the petitioner's argument that Rule 150A contradicts the Act. With clarifications, the Supreme Court disposed of the special leave petition. The Supreme Court ordered the release of a Tata tipper lorry seized in September 2021 in connection with a criminal case in Tamil Nadu, observing that keeping the vehicle idle was not in anyone's interest as it occupied public space within the magistrate's court complex. A bench of Justice Rishikesh Roy and Justice S.V.N. Bhatti was hearing the matter. The Supreme Court deemed it appropriate to release the Tata tipper lorry subject to certain conditions. Number 1. The petitioner must furnish a bond of Rs 5 lakhs to the satisfaction of the trial court. The petitioner must undertake to produce the vehicle before the court as and when required. Number 3. The petitioner must not create any third-party rights for the vehicle in question. With these conditions, the Supreme Court allowed the special leave petition to the extent indicated, enabling the release of the lorry from custody. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just Rs 89 per month.